Be ready now. I am going to dictate a legal passage on latest Supreme Court judgment at the rate of 120 words per minute. 5, 4, 3, 2, 1. Let's start. The appeal challenges the judgment and order passed by the High Court of Madhya Pradesh dated 20th November 2009, whereby the High Court has partly allowed the appeal filed by the present appellants. The learned 5th Additional Sessions Judge, Indore, had convicted the appellants under Section 148 and Section 304, Part 1, of the Indian Penal Code, for short, IPC, read with Section 149 of the IPC, and sentenced them to undergo RI for 2 years for offence under Section 148 IPC and RI for 10 years for offence under Section 304, Part 1, with a fine of 2,000 rupees, rupees 2,000 only, in default of payment of fine, to suffer additional RI for 6 months. The High Court, while confirming the conviction under Section 304, Part 1. The prosecution case in brief is that there was a dispute between accused persons and one Mr. Guman Singh, father of deceased Jeevan Singh, on account of purchase of land of one Gulab Singh by the accused. It is the prosecution case that on 23 April 1997, when deceased Jeevan Singh was going to a vegetable market, Indore, for selling the vegetables on his scooter, at around 7:30 am, when he reached in front of the house of one Ramlal in village, all the appellants armed with axe, parsa and dhariya started assaulting Jeevan Singh. Jeevan Singh fell down on the ground from the scooter. FIR came to be lodged by P.W.6 Padam Singh. Since the deceased was admitted to the hospital, initially the FIR came to be lodged for the offences punishable under Sections 307, 147, 148 and 149 of the IPC. The statement of the deceased was also recorded by the police on the same day, in which he named all the appellants. The appellants were apprehended, and on their disclosure statement, weapons were seized. After 4 days of hospitalization, the deceased died on 27 April 1997. After completion of the investigation, charge sheet was filed for offences punishable under Sections 147, 148 and 300 and to read with Section 149 of the IPC in the court of competent judicial magistrate, and the case was committed to the Sessions Judge. The learned Sessions Judge passed the aforesaid order of conviction. In the appeal before the High Court, the High Court confirmed the same. Shri Sushil Kumar Jain, learned senior counsel appearing on behalf of the appellants, submits that none of the injuries sustained by the deceased were on the vital parts of the body. Injuries were only on the hands and legs. It is therefore submitted that it cannot be said that either the appellants had an intention or knowledge that injuries caused would result in death. He therefore submits that the case at the most would fall under Sections 325 or 326 of the IPC. He submits that for the said offence the period undergone, i.e. 3 years and 5 months, would subserve the ends of justice. Shri Harmeet Singh, learned counsel appearing on behalf of the respondent state, on the contrary, submits that the High Court has already taken a lenient view in the matter and has reduced the sentence from RI for 10 years to 7 years. He, therefore, submits that, as a matter of fact, the instant case would fall under Section 302 of the IPC, inasmuch as the appellants armed with deadly weapons had waylaid the deceased on account of previous enmity. He further submits that as many as 09 injuries have been sustained by the deceased and, therefore, prays for dismissal of the appeal. With the assistance of the learned counsel for the parties, we have scrutinized the evidence on record. From the perusal of the evidence of Dr. Saroj Gharni, Assistant Surgeon, it is revealed that the deceased has sustained the following injuries.